What if the most fundamental parts of your life, your home, your belongings, even the future you dream of suddenly weren't yours anymore, simply because you said, "I do"? Imagine a world where your very identity as a property owner could vanish overnight. Welcome to 1152. Number 1. The vanishing act of her property upon marriage. Picture this. You're a young woman in 1152, perhaps the daughter of a merchant or a landholder. You might have inherited a small plot of land, some livestock, maybe a chest overflowing with beautiful linens and a few silver coins. You've managed your own affairs, made decisions about your modest wealth, perhaps even traded goods at the local market. You are in legal terms feme sole, a woman on her own with all the limited but very real rights that status afforded. Then comes the day. You meet a man, fall in love, and vows are exchanged. You become a wife. And just like that, almost as if by magic, or rather, by an invisible legal spell, your personal property, the things you called your own just yesterday, are no longer truly yours. They have in essence performed a vanishing act. This wasn't some minor inconvenience. It was a fundamental shift in legal identity known, in some emerging legal traditions, as feme covert. It meant that upon marriage, a woman's legal existence, particularly concerning property, became subsumed under that of her husband. He didn't just manage her assets, he became the legal owner of most of them. Think of it like this: your husband became the sole captain of a ship, and anything you brought aboard, whether it was your personal treasure chest or the very planks of the deck, immediately became part of his command. This was the widely accepted legal principle known as jure uxoris, meaning by right of his wife, but it wasn't a right she held, it was a right he gained over her. Let's dig into what this really meant on the ground. Take Alara, for instance, a hypothetical woman from a middling family in a thriving English village. Before her marriage, Alara owned 3 cows, a small orchard of apple trees, and a sum of silver pennies she had diligently saved from selling her embroidery. The day after her wedding, those cows, that orchard, and every single penny she possessed were, by customary law, under the complete control and ownership of her husband, Thomas. Sell the cows, fell the apple trees for timber, or spend the silver on new tools or a night at the alehouse, all without needing Alara's permission or even her knowledge. This wasn't theft, it was simply the law of the land, a deeply ingrained custom inherited from Germanic legal traditions and reinforced by the evolving legal systems of the 12th century. Legal treatises of the time, such as those beginning to compile customary law, reflect this reality with stark clarity. This wasn't just about immediate possession. It was about rights of alienation, the ability to sell, mortgage, or give away property. Once Alara's property became Thomas's, she lost her right to do any of these things. Her beloved orchard fell into disrepair. She couldn't simply hire laborers to prune the trees or sell some apples to pay for their upkeep without Thomas's explicit agreement. If she saw an opportunity to trade her cows for a more fertile pasture, she couldn't act on it. Economic agency, which had been limited but present as a single woman, was now almost entirely extinguished. The logic behind this, if one could call it that from a modern perspective, was rooted in the patriarchal structure of medieval society. The husband was considered the head of the household, responsible for its protection, sustenance, and legal representation. To effectively fulfill this role, he needed absolute control over all household resources. A married woman was deemed legally incapacitated for many actions, similar to a minor or someone considered of unsound mind. Her identity was merged with her husband's, creating a unified legal entity, but one where the husband's will dominate. This legal concept was so pervasive that it stretched from the highest noble families down to the humblest peasants, adapting slightly to local customs, but retaining its core principle. The only exception was often a concept known as paraphernalia, which usually referred to a woman's personal clothing and ornaments. Even these items, however, were often considered her husband's property during his lifetime, and she could only truly claim them after his death. Consider the ripple effects. What if Alara's family had intended for that orchard to be a source of future income for her, perhaps for her old age or for the dowries of her future daughters? Once married, that intention was irrelevant to the law. Thomas could, theoretically, use the orchard as collateral for a loan, and if he defaulted, the orchard could be seized by his creditors, regardless of Alara's original ownership or wishes. She would have no legal standing to prevent this. Her rights were filtered through him, and his decisions, even detrimental ones, were binding. The legal chronicles of the era, while not always focusing on individual women's plights, implicitly confirmed this reality by detailing land transfers and transactions that rarely required a wife's independent consent for her original property once married. The husband simply was the owner for all practical purposes. This wasn't merely custom, it was becoming enshrined in the nascent legal frameworks, shaping the lives of every married woman in ways that fundamentally altered their relationship with wealth and control. Number 2, the dowry dilemma, given away but not her own. Imagine you're a young woman from a respectable family in 1152. Your parents have spent years preparing for your marriage, not just emotionally, but financially. They gather a significant portion of their wealth, perhaps a sum of money, a piece of land, valuable goods like livestock, tools, or bolts of fine cloth. This isn't a gift to you, it's a dowry, or in some regions like England, a maritagem, and it's given by your family to your husband or to the newly formed couple upon your marriage. On the surface, it seems like a great advantage. It enhances your standing, solidifies the alliance between your families, and is supposedly meant to provide for your upkeep and the future of any children you might have. Here's the catch, the core of the dilemma. Once that dowry leaves your family's hands and enters the marriage, it is no longer truly yours to control. It becomes, for all intents and purposes, your husband's. This arrangement was widespread across Europe, though its precise legal implications varied slightly by region and local custom. In areas influenced by Roman law, the dowry, known as dues, was a formal transfer of property. In England, the maritagem served a similar function, often a grant of land given by the bride's father to the groom, with the understanding that it would eventually revert to the bride's family if the marriage failed or if there were no children. Regardless of the name, the principle remained similar. The husband gained immediate control and usually full ownership of the assets. He could use them, profit from them, and often dispose of them. Let's consider Gisela, a high-born lady whose family provided a substantial dowry of several manors and a large sum of coin to her future husband, Lord Roland. The intention was clear. This wealth was to support Gisela in her new station, secure the legitimacy of their offspring, and provide for her if Roland died. The moment the marriage contract was sealed, those manors and that coin chest became Roland's to manage. He could lease the manors, collect rents, and spend the money as he saw fit. Roland decided to embark on a costly military campaign. He could, and often would, use the dowry lands as collateral for a loan or even sell a portion of them outright to finance his endeavors. Gisela would have little to no say in these decisions. While it was generally understood that the dowry was intended for her and their children, there was no legal mechanism for her to prevent its dissipation or ensure its preservation if her husband was financially reckless or simply chose to prioritize other expenses. What if Roland was a gambler or engaged in ill-advised ventures that led him into debt? Dowry, which was supposed to secure Gisela's future, could be seized by Roland's creditor. The family who had meticulously assembled that wealth would have no legal recourse to reclaim it. The assets, once transferred, were simply part of Roland's estate. Early legal commentators and charters of the period demonstrate how these transfers were recorded as belonging to the husband, sometimes with a vague clause about the wife's use, but rarely with any enforceable right to control. Dowry's status was particularly precarious if the marriage dissolved. Divorce, as we understand it today, was virtually non-existent in 1152. Marriages were dissolved only through annulment by the church, usually on very narrow grounds like consanguinity or pre-existing vows. If a marriage was annulled, the dowry might in some circumstances be returned to the wife's family, but this was a complex and often protracted legal battle with no guarantee of success. If the wife died childless, the dowry property might revert to her family in some regions, but only after her husband had enjoyed the full use and profit from it for the duration of the marriage. And if she had children, the property usually remained with the husband and his lineage, ensuring that the wealth stayed within the new family, but forever out of her direct control. Think about the psychological impact. Gisela knows that her future, her children's future, and her security are tied to assets that she cannot influence or protect. Dowry was a crucial part of marriage negotiations, often determining the status and desirability of a bride. Yet for the woman herself, it represented a profound loss of direct control over a significant portion of her family's contribution to her new life. It was a promise of security that could be easily broken by a husband's poor judgment, an unfortunate turn of events, or even deliberate financial mismanagement, leaving her vulnerable and dependent on his whims or the charity of her natal family. Dowry was given for her, but it was rarely her own in any meaningful sense beyond her symbolic association with its presence. Number 3. Dower's double edge, a mere life interest. You've heard of dower, right? It sounds like something beneficial, a provision for a woman, and in some ways it was. Dower was the primary legal protection for a widow in 12th century England and other regions influenced by Anglo-Norman customary law. Granted a wife, upon her husband's death, a lifetime interest in a specific portion of his land, typically 1/3. The idea was to prevent a widow from becoming utterly destitute, a burden on her family or the community. Provided her with a means of support after her husband, the primary provider, was gone. Before you breathe a sigh of relief for the medieval woman, here's the stark truth. Dower was a right of use, not ownership. It was a lifeline, yes, but a very tightly tethered one, with a sharp double edge that cut deeply into any real sense of autonomy or long-term security. Imagine a leaner, whose husband, a minor baron, suddenly dies. She is granted her dower, let's say, 1/3 of his estates, including a manor house, some tenant farms, and a portion of his forests. This means she can live in the house, collect rents from the tenants, and take timber from the forest for her needs. She has income, a roof over her head. Here's the crucial limitation. She holds this land for her lifetime only. This is what life interest truly means. She cannot sell that land, she cannot mortgage it, and she cannot bequeath it to her children or anyone else when she dies. When a leaner passes away, that dower land immediately reverts to her husband's heir, typically his eldest son. It doesn't become part of her own estate to pass on. This limitation severely curtailed a widow's economic power and long-term planning. While she could live off the land, she couldn't make significant capital improvements that would bind the next generation, nor could she use the land to raise capital for her daughter's dowries or her younger son's training, unless such arrangements were explicitly agreed upon by the heir. The land was held in a sort of legal limbo, ensuring its preservation for the main lineage, but restricting the widow's ability to maximize its potential or dispose of it as she saw fit. She was a temporary custodian, not a true proprietor. Furthermore, the very nature of dower meant it was often contested. The husband's heir, usually his eldest son, had a vested interest in the dower land reverting to him as quickly as possible. This could lead to strained relations and even legal disputes. The widow might have to fight to secure her dower portion, especially if her husband had many debts or if the heir was reluctant to relinquish control. Legal records from the period often contain cases of widows seeking to claim their dower, highlighting the challenges they faced in asserting even this limited right. The Magna Carta itself, a few decades later, had clauses affirming a widow's right to her dower, indicating how often it was denied or delayed. What if a leaner wanted to move, perhaps to be closer to her children or grandchildren? She couldn't simply sell her dower lands and buy property elsewhere. She would have to find someone to manage it, or perhaps lease it, but the capital remained tied to the land she did not truly own. Her ability to relocate or change her circumstances was profoundly restricted by this binding connection to property that was not her own, only granted for her sustenance. Dower also faced challenges if the husband had already alienated much of his property before his death. While theoretically, a wife's dower right could attach to all lands held by her husband at any point during their marriage, proving this could be incredibly difficult. A husband might have sold off portions of his estates or mortgaged them, and the buyers or creditors would have a competing claim. Covering her dower from such transactions would have been a monumental legal undertaking, likely requiring costly and prolonged court battles. So while dower offered a degree of protection against absolute poverty, it was a far cry from true property ownership or economic independence. It ensured a widow's survival, but it did not empower her to build wealth, make independent investments, or plan for a future beyond her own immediate needs. Control over the land was superficial and time-limited, always overshadowed by the ultimate claim of her husband's male heirs. It was a provision, a conditional use, a temporary dwelling in a house that belonged to someone else's line, underscoring the deep-seated inequity in how property rights were conceived for women in medieval society. Number 4, the husband's carte blanche, selling her land. Imagine this scenario. You inherit a valuable piece of land from your mother, perhaps a vineyard or a productive grain field. It's been in your family for generations, a tangible connection to your lineage, a source of income and pride. You marry, and while your husband legally takes control of its management, you assume that because it was your inheritance, it remains fundamentally tied to you and your future children. Then comes the day when your husband decides to sell it, without consulting you, without your enthusiastic consent, perhaps even against your fervent wishes. This wasn't a rare occurrence in 1152. It was a common, and often devastating, reality for married women, reflecting one of the most profound inequities in marital property rights. The husband held a virtual carte blanche to alienate, or sell, her inherited land, often with minimal legal hurdles. This principle stemmed directly from the jure uxoris discussed earlier, where the husband gained extensive control over his wife's real property upon marriage. While a wife's inherited land, her inheritance or peerage in some legal contexts, was distinct from her dowry, it still fell under her husband's dominion. He might not own it in the same sense he owned his own ancestral lands. It was understood to be her inheritance, but his control over its disposition was almost absolute during their marriage. Legal traditions, particularly the evolving English common law and various continental customary laws, generally allowed the husband to convey his wife's lands, whether by sale, gift, or mortgage, largely at his discretion. Let's think of Lady Isolde, who brought a substantial estate, rich in timber and grazing lands, to her marriage to Sir Gareth. This land was part of her family's ancient holdings, intended to pass through her to her own children. Sir Gareth, facing financial difficulties from a failed venture, or needing funds for a crusading expedition, could decide to sell a portion of Isolde's inherited estate. He might go through a nominal process of securing her consent, but in a society where women had little legal standing independent of their husbands, and where spousal coercion was often unchallengeable, such consent was frequently a mere formality, if it was sought at all. A wife might be brought before a court or a witness, asked if she agreed, and she would be expected to affirm it. To refuse could lead to severe domestic consequences, social ostracization, or worse, leaving her with no real choice. The legal chronicles and court records of the period, when they mention wives' involvement in land transfers, often note their presence but rarely their independent agency. The concept of a fine of lands, or final concord, which emerged later in English law as a way to protect a wife's dower or inherited rights by requiring her separate examination, was still in its very early stages in 1152 and not universally applied or effective. For the most part, a husband could proceed with a sale or transfer, and the transaction would be considered valid. If Isolde attempted to object after the fact, her recourse would be limited. She could try to argue that her consent was coerced, but proving this would be incredibly difficult against her husband's word, especially given the hierarchical nature of medieval family structures. The purchaser of the land would also have a strong legal claim, having acquired it from the recognized head of the household. This inequity extended beyond just sales. A husband could mortgage his wife's inherited land to secure his own debts. If he defaulted, the land could be foreclosed upon, passing out of the wife's lineage permanently. He could lease it for long terms, effectively denying her or her children future control over its use or income. He could even gift parts of it to his own kinsmen or to the church, further diminishing her family's patrimony. While it might seem contradictory to modern minds that property acknowledged as hers could be disposed of by someone else, in the medieval legal framework, the husband's managerial and dispositive powers over all marital property were generally paramount. The implications for women were profound. Their inherited wealth, which was often intended to secure their future and the future of their offspring, could be unilaterally diminished or entirely lost by their husbands. This left women feeling powerless, their family's legacy vulnerable to their husbands' decisions, good or bad. It reinforced their dependency and highlighted that even the most ancient and cherished family holdings were, in the eyes of the law, ultimately subject to male authority within the marital bond. This deeply entrenched custom was not merely about control. It was about the legal system actively upholding the husband's right to act upon property that, in other contexts, was understood to be his wife's by inheritance, effectively erasing her agency within the marital unit. Number 5. No wills, no way, silenced in death. Imagine living a life where you accumulate personal possessions, perhaps cherished jewelry, fine clothes, or a small hoard of coins. You might have aspirations of leaving these items to your beloved daughter, or donating a portion to the local church, or even providing for a faithful servant. You might have plans for how your modest wealth could benefit those you care about after you're gone. But in 1152, if you were a married woman, these aspirations were largely irrelevant. Your ability to make a will, to dictate the distribution of your own personal property upon your death, was severely restricted, if not entirely denied, without the explicit consent of your husband. This was a profound silence, a legal silencing of a woman's final wishes, reflecting a pervasive inequity in her proprietary rights. Prevailing legal principle, particularly concerning chattels, movable goods like clothing, jewelry, furniture, money, and livestock, was that they generally belonged to the husband. We touched upon this when discussing the vanishing act of her property upon marriage. Even if she brought these items into the marriage, or acquired them during the marriage through gifts or her own labor, they became part of the husband's property. Therefore, she could not bequeath what was not legally hers. Consider Matilda, a prosperous miller's wife. Over years, she had accumulated a beautiful silver brooch, a collection of useful cooking pots, and a small purse of coins from selling her surplus eggs and cheese at the market. She envisioned her brooch going to her eldest daughter, the pots to her younger, and the coins to help a struggling neighbor. However, the moment she married those items, unless they were specifically designated as her paraphernalia, which was a very narrow category, usually restricted to clothing and ornaments, and even then often controlled by the husband, legally transferred to her husband's ownership. Matilda wished to make a will. Even for these personal items, she would need her husband's express permission. And even with his permission, her will would be subject to his approval and could not contradict his own rights to the marital chattels. This was not a minor detail. The right to make a will was a significant legal power in the medieval world. It allowed individuals, particularly men and single women, to shape their legacy, to provide for their souls through charitable bequests to the church, and to distribute their wealth among their heirs as they saw fit, often ensuring the continuity of their family's economic standing. For married women, this power was largely absent. Their husbands dictated the ultimate disposition of all marital property, including items that had originated with the wife or that she felt were personally hers. The husband died first. The chattels would form part of his estate, to be distributed according to his will or the rules of intestate succession, with the wife typically only having a right to a portion of the household goods necessary for her continued living. The church, which oversaw the execution of wills, especially concerning bequests for the soul, generally recognized the husband's paramount control over marital property. While a woman might make a small devotional gift with her husband's permission, anything substantial that impacted the family's assets would be subject to his agreement. This meant that a married woman had little say in how her accumulated wealth, even her personal earnings, would be used after her death. Her identity, legally and economically, was so intertwined with her husband's that her own desires for her legacy were largely superseded by his authority. Think of the contrast with single women or widows. Feme soul had the full right to make a will for all her property, real and personal. This gave her a degree of economic independence and control that was completely denied to her married counterparts. The very act of marriage, which was supposed to bring partnership and security, paradoxically stripped a woman of this fundamental right of disposition. This inequity reinforced the idea that a married woman was not an independent economic agent, but rather an appendage to her husband. Her wishes and even her spiritual welfare, often mediated through his authority, and his ultimate decisions regarding the disposal of their shared, but legally his, wealth. The silence in her death regarding her property was a stark continuation of the legal silence she experienced throughout her married life. Number 6, debts and dispossession. His burdens, her loss. Imagine a situation where your partner incurs significant debts. Perhaps they make a series of bad investments, or they are held responsible for a large payment in a legal dispute, or they simply live beyond their means. Now imagine that your property, even assets you brought into the relationship, could be seized by creditors to settle his financial obligations, leaving you impoverished and without recourse. This wasn't a hypothetical fear for married women in 1152. It was a very real and prevalent risk, illustrating another profound inequity. A husband's debts were often the wife's loss, with her original property being vulnerable to his financial misadventures. The legal reality was straightforward. Because a husband gained control and often ownership of his wife's real and personal property upon marriage, all marital assets were generally considered his for the purpose of debt collection. There was no concept of separate property for a married woman in the modern sense, nor was there a clear distinction between the husband's individual debts and the family's debts. In the eyes of the law, the husband was the legal head of the household and its sole financial agent. His financial responsibilities, therefore, extended to everything under his dominion, which included his wife's former property. Let's consider Agnes, who came from a modest but respectable family and inherited a good sum of money, perhaps enough to purchase a small holding of land. She married Robert, a man who, unbeknownst to her, had a penchant for gambling or perhaps made unfortunate business deals with other merchants. Robert accumulates significant debt. When his creditors come calling, they don't differentiate between the money Robert earned or inherited and the land Agnes brought into the marriage. That land, now under Robert's legal control, is fair game for seizure to satisfy his creditor. Agnes would watch helplessly as the property that was once her security, her inheritance, was taken away to cover her husband's liabilities. She had no legal standing to argue that the land was hers or that it should be exempt from his debts. It was simply part of the marital estate, over which he had legal dominion, and thus it was available to his creditors. This vulnerability extended to all types of property. Agnes had brought valuable personal goods, like a chest of silver plate or fine linens. These too could be seized. Robert's debts were severe enough to force the sale of the family's main estate. Any dower rights Agnes might have hoped for upon his death would be compromised or extinguished, as his creditors would have prior claim to the property. This was particularly devastating for women who had substantial dowries or inherited lands, as their family's carefully constructed wealth could be wiped out due to the husband's poor financial decisions or misfortune. There were very few, if any, legal mechanisms for a wife to protect her property from her husband's creditors. She could not sign a separate legal agreement to keep her property distinct. She could not sue on her own behalf to prevent the seizure. Her legal identity was so fused with her husband's that his financial burdens became hers by default, without any corresponding legal power for her to manage or mitigate those risks. Even if the debts were incurred long before the marriage, or were clearly connected to ventures entirely separate from their household economy, the effect was often the same. The implications were dire. A woman who entered a marriage with assets could find herself stripped of everything, left utterly dependent on a husband whose financial recklessness or bad luck had left them both destitute. This not only affected her present security, but also her future prospects and the well-being of her children. A woman's ability to secure her own position or to provide for her offspring was fundamentally undermined by her husband's unchecked financial authority. It was a clear demonstration that despite property often being transferred through the wife, its ultimate fate rested entirely on the husband's economic prudence and legal standing, leaving her to bear the consequences of his burdens without any direct legal recourse to protect her own interests. Number 7, legal limbo. She can't sue, she can't be sued. Imagine a situation where someone steals your most cherished possession, or a neighbor encroaches on your land, or a merchant reneges on an agreement. In a just world, you would have the right to seek legal redress, to go to court, to protect your interests. But in 1152, if you were a married woman, you were often trapped in a legal limbo. You generally could not initiate legal action in your own name, nor could you be sued directly. Any legal matter concerning property, contracts, or even personal wrongs that affected you had to be pursued by or through your husband. This fundamental lack of legal standing was a profound inequity, stripping women of their ability to independently defend their rights and interests. This principle was a direct consequence of the feme covert status. A married woman was, in the eyes of the nascent legal systems, legally incapacitated. Her legal identity was merged with her husband's. He was her legal representative, her baron or lord in a legal sense. Therefore, if a dispute arose over land that had been hers before marriage, or if her personal property was stolen, she could not personally bring a case to the king's court, a local manorial court, or a church court. Her husband had to do it on her behalf. Let's illustrate with the case of Lady Catherine. She inherited a valuable piece of land from her aunt before her marriage to Sir Richard. After their wedding, a neighboring lord began encroaching on her land, cutting down trees and diverting a stream. If Catherine were a single woman, she could file a legal complaint, present her claim, and defend her property in court. As a married woman, however, she could not. She would have to persuade Sir Richard to take up the case. If Sir Richard was preoccupied with his own affairs, or lacked the financial means, or simply wasn't bothered by the encroachment, Catherine would be powerless. The land, though still recognized as her inheritance, was legally defensible only by him. If he chose not to act, her rights, effectively, withered away. This legal dependency extended to being sued as well. If a merchant claimed an outstanding debt from Catherine's family, incurred before her marriage, perhaps, or if someone accused her of a breach of contract, which would be rare for a married woman to enter into, the legal action would be brought against her husband. He would be the one to answer in court, to defend the claim, and to bear the consequences. This might sound like a protection, but it actually reinforced her lack of agency. She was not a party to the legal process, even when the matter directly concerned her person or her property. The implications were far-reaching. It meant that a married woman could not independently enter into contracts, buy or sell property, even goods for her household, or make loans, because she lacked the legal capacity to be bound by such agreements. Any such transaction would typically require her husband's participation and consent, making him the legally responsible party. This severely limited her economic opportunities and her ability to conduct independent business. While some local customs or urban charters might have offered minor exceptions for women engaging in trade, especially widows, for the vast majority of married women, their ability to act in the legal and economic sphere was severely curtailed. Consider the challenges in securing justice. Catherine was slandered or personally harmed, her husband would be the one to seek recompense. While he might do so out of a sense of honor or duty, the primary legal recognition was of the wrong done to him through his wife, rather than a wrong done to her as an independent individual. This legal framework emphasized the husband's role as protector and manager, but in doing so, it effectively erased the wife's individual legal personality, leaving her in a state of perpetual legal limbo, dependent on her husband's willingness and ability to act on her behalf for any legal matter, however personal or significant. Number 8, the morning gift, a fading promise. The morning gift sounds rather romantic, doesn't it? Tradition deeply rooted in Germanic customs, where the husband, the morning after the wedding night, would present his new wife with a gift as a token of appreciation for her virginity and her entry into his household. This gift could be anything from a piece of jewelry, a sum of money, or even a small portion of land. It was meant to be hers, a personal possession to provide for her needs, distinct from the dowry her family might have brought to the marriage. However, like many good intentions within the complex legal landscape of 12th century marital property, the morning gift often proved to be a fading promise, its substance and long-term benefit for the woman often dissolving into the broader inequities of the time. While the concept of a morning gift, morgengabe in Germanic traditions, or similar customs in Anglo-Saxon England before the Norman conquest, persisted in some form in 1152, its significance had often diminished or been subsumed into other property arrangements. In many regions, particularly those influenced by the evolving English common law, the dower, the widow's right to a third of her husband's lands for life, became the predominant and more legally robust form of provision for a wife after her husband's death. The morning gift, if it was still practiced, often became less of a significant independent asset and more of a symbolic gesture, or its legal standing was ambiguous. Let's imagine Lady Isolde receives a beautiful gold torque as a morning gift from her new husband, Lord Edward. She cherishes it, as it is a direct personal gift to her, but what is its actual legal status? Does she truly own it in the same way an unmarried woman would own her jewelry? The answer, more often than not, was no. Under the prevailing principle of jure uxoris, any personal property that came into the marriage, including gifts received by the wife during the marriage, generally fell under the husband's control and ownership. While it was given to her, it was then managed by him. He might not sell her specific torque, but he technically had the right to do so, or it could be seized by his creditors if he faced financial ruin. Even if the morning gift was a small piece of land, its value could be nominal compared to the husband's overall estate, and its ownership would still be overshadowed by his legal dominion. He would manage it, collect its produce, and its ultimate disposition would be subject to his will or the rules of inheritance, rather than hers. rarely provided a substantial independent income stream or a source of capital that she could freely use or dispose of. The promise of the morning gift was that it was hers, but the reality was that it was hers only in name, still fundamentally controlled by her husband. Furthermore, the morning gift was often overshadowed by the larger financial stakes involved in marriage. Dowry from the wife's family and the dower, the husband's provision for his widow, were the key economic considerations, often codified in formal marriage agreements. The morning gift, by comparison, might be an informal custom, or it might be a small fixed sum or item, rather than a negotiable or significant asset. Its inclusion in legal documents was less common, making it more vulnerable to disputes or being simply overlooked in the broader framework of marital property. Consider the practical implications. If a woman's morning gift was, say, a small cottage and garden, she might live there or enjoy its produce, but could she rent it out independently? Could she sell it if she needed urgent funds for her family without her husband's consent? Could she ensure it passed to her favorite daughter if she died before her husband? The answer to these questions was almost universally no. The morning gift, while a sweet gesture, ultimately highlighted the broader legal subservience of the wife within the marriage. It was a token of affection and a nod to ancient tradition, but it did not grant her independent property rights or significant economic power in a legal system that overwhelmingly vested control in the husband. It was a reminder of what she might have had, if not for the overarching legal structures that rendered her ability to truly own and control property a fading dream. Number 9, the peril of annulment or separation, losing it all. Imagine dedicating years of your life to a marriage, perhaps bearing children, managing a household, and contributing to the prosperity of your family. Now imagine that the legal validity of that marriage is suddenly questioned, or circumstances force a separation. And with that, you face the devastating prospect of losing all access to the property you brought into the marriage, or any assets accumulated during your time together. This was the stark peril for women in 1152 facing annulment or separation, a situation where the legal concept of marital assets as jointly owned simply did not exist for them, leading to a profound loss of security and a near-complete dispossession. In the 12th century, divorce as we understand it today, a legal dissolution of a valid marriage, was not possible. The Church, which held ultimate authority over marriage, considered it a sacrament, indissoluble except by death. However, marriages could be annulled, meaning declared null and void from the beginning. This typically happened on very specific and narrow grounds, such as consanguinity, the parties being too closely related, pre-contract, one party having a prior, unfulfilled marriage promise, impotence, or lack of proper consent. Annulment was not a common occurrence, but when it happened, its consequences for the woman's property were catastrophic. If a marriage was annulled, it was as if it had never legally existed. This meant that any property the woman brought into the marriage, her dowry, her inherited lands, her personal chattels, was supposed to revert to her or her natal family. However, the reality was often far more complex and harsh. The husband, having had legal control and use of these assets for the duration of the annulled marriage, might have already alienated them, spent them, or incurred debts against them. Claiming these assets could involve lengthy, expensive, and often futile legal battles, particularly if the property had already changed hands multiple times. There was no concept of a fair division of property accumulated during the annulled marriage. Since the marriage was deemed never to have happened, the wife had no legal claim to anything beyond her original contributions, and even those were difficult to recover. Consider the hypothetical case of Lady Isolde, whose marriage to Lord Roland is annulled after 5 years due to a newly discovered distant familial relationship. Isolde brought a substantial dowry of land and silver. During those 5 years, Roland managed the land, collected its revenues, and spent the silver on his own ventures. Upon annulment, Isolde is expected to return to her family. Her dowry lands, if not sold, would theoretically revert to her, but Roland would have enjoyed all the profits for 5 years. The silver she brought, likely spent, would be almost impossible to reclaim. Any wealth accumulated during their marriage through Roland's management of the combined properties would be considered his entirely. She had no claim to it. She would essentially walk away with nothing but what she could physically carry, and often not even that if her original property had been dissipated. Even in cases of formal separation, which was rarer and typically involved a divorce a mensa et thoro, separation from bed and board but not a dissolution of the marriage. The woman's economic situation was dire. She might be granted some alimony or maintenance by her husband, but she would still have no independent control over her original property, which remained under his legal dominion as long as the marriage technically existed. She would be dependent on his provision, not her own property rights. The peril extended to the future of the children as well. If the marriage was annulled, the children could be declared illegitimate, impacting their inheritance rights and social standing. While this wasn't directly about the woman's property, it highlighted the profound vulnerability of her entire social and economic position when the legal foundation of her marriage was shattered. The legal system offered no concept of community property or equitable distribution upon dissolution. It focused on the premarital state, which was often impossible to fully restore, especially after years of the husband's unimpeded control over all assets. This created an immense insecurity for women. Her entire economic future, her very ability to survive, rested on the unchallenged and continued validity of her marriage and her husband's good stewardship. Should the marriage fail for whatever reason, the legal framework offered her minimal protection and often left her utterly dispossessed, a stark testament to the profound inequity of her property rights within the marital bond. She invested her life, her labor, and her family's wealth into a union, only to find that if it crumbled, she was left with little to nothing. Number 10. Her chattels his call, personal property predicament. Imagine spending years acquiring items that define your personal space and comfort, your clothing, your jewelry, your household goods like pots, pans, and furniture, perhaps even a small sum of saved money. These are not grand estates or vast sums, but the everyday objects that constitute your world. Now imagine that upon marriage, these intimate possessions, your chattels, automatically become the property of your husband, to do with as he pleases. This was the deeply personal and often overlooked inequity faced by women in 1152. Her personal property, her chattels, were largely her husband's call, reflecting a total lack of distinct personal proprietary rights within the marital unit. This was perhaps the most pervasive and tangible aspect of the jure uxoris principle, affecting women of all social classes. While discussions often focus on land, which was the primary form of wealth, the transfer of chattels hit much closer to home for most women. Whether she was a noblewoman with elaborate gowns and jewels or a peasant wife with her spinning wheel and a few chickens, the underlying legal principle was the same. Once married, these movable goods became the husband's. Let's take the example of Agnes, a farmer's daughter. She meticulously sewed her trousseau of new clothes, inherited a few precious silver spoons from her grandmother, and had a small cache of coins saved from selling her garden vegetables. When she married John, all of these items instantly became his legal property. He could sell the spoons if he needed extra money. He could pawn her clothes, though this was less common for social reasons, and her accumulated coins were simply absorbed into his household funds. Agnes had no legal right to prevent this, nor could she claim them as her own. The husband's control over chattels was even more absolute than over land, which sometimes had more specific rules for inheritance or dowry. Personal property, the husband's dominion was generally complete and unquestioned. He decided to sell a herd of cows that had belonged to his wife before marriage, or a collection of tools she had inherited. He was within his legal rights. The exception, as mentioned earlier, was paraphernalia, a very narrow category usually restricted to a woman's necessary clothing and personal ornaments. Even these were often considered her husband's property during his lifetime, and she could only claim them upon his death, provided he hadn't already disposed of them. This meant that a married woman had virtually no independent economic sphere for personal property. She could not engage in independent trade, sell goods, or make contracts concerning chattels without her husband's consent, because anything she might acquire or dispose of would be considered his transaction. This severely limited her ability to earn or manage her own money, even for small personal needs or luxuries. Any money she made, for example, from selling eggs or weaving cloth, immediately became her husband's. The impact of this was not merely financial, it was deeply personal. The inability to own or control one's own clothing, jewelry, or household items was a constant reminder of a woman's diminished legal status within her own home. Choices about these items were always subject to her husband's authority. Chose to sell her favorite brooch, she had no legal recourse, only persuasion, which might or might not work depending on their relationship. The concept of her belongings, cherished for their sentimental or practical value, was a social nicety, not a legal reality. This profound inequity permeated daily life, affecting every aspect of a married woman's existence. Personal wealth, her comfort, her ability to make independent choices about even the most modest possessions were entirely dependent on her husband's goodwill and financial prudence. It underscored that within the marital bond of 1152, a woman's identity as a property owner was not merely diminished. For chattels, it was almost entirely eradicated, leaving her legally dependent on the call of her husband for every item she owned, regardless of its origin or her emotional attachment to it.